morning, Your Honors. May it please the Court. My name is Fletcher Ogundeyi. With me here is my co-counsel, Oluwaseyi Banjo. We represent the petitioner, Fern Arable, and the other parents in this case. The petitioners will be addressing two issues today, leaving 2 minutes for rebuttal. With the kind permission of this honorable court, I would like to proceed.
You may proceed, counsel.
Thank you, Your Honor. The petitioner respectfully requests that this honorable court clarifies the scope of the school board authority in the corresponding breadth of the constitutional rights retained by parents once their child enters a public school, which has raised two fundamental and constitutional questions. First, whether the Templeton School District violated the parents' 14th Amendment Due Process Clause when it launched and introduced a highly sensitive lessons to its students without parental knowledge or content. Second, whether the school board's elimination of critical race theory and related topics violates the students' First Amendment rights of free speech by restricting their access to information and ideas. I would like to address the first issue, but before then, here is the fact in brief. The Templeton School District started a program called America the Beautiful under Operation 1776, meant to promote pride in American culture and history. As part of the program, first and second grade students had to attend mandatory assemblies 3 times a week about patriotism and assimilation. Parents were not told in advance and cut off their child out. After the program began, some children stopped speaking their home languages and rejected their cultural backgrounds. At the same time, the district banned critical race theory and related and other similar materials, saying they cause racial tension. This happened in a community that is 95% non-white, with 72% of home speaking English as a second language. Many parents said they wanted to teach their children about race and identity at home, not through a government-controlled program. Because of this, the petitioner filed a lawsuit under 42 U.S.C. Section 1983, claiming that the district violated the 14th Amendment Parents' Due Process Clause to direct their children's education and the First Amendment students' free speech right. Your Honor, the Supreme Court has long upheld the fundamental right of parents to direct the care, custody, and education of their children. Yet, the school district disregarded this well-established principle by implementing a mandatory program without obtaining parental consent. This overreach is especially troubling, given that the children affected ages 6 to 8 are at a critical impressionable stage where educational influences leave deep and lasting impression. This program caused real harm at home. For example, one of the children refused to speak his family's native language after being told in school that speaking only English was the way to be a true American. This created a communication barrier in a community where most families speak another language at home. America is a diverse nation with a strong constitutional foundation of individuals, and its civil rights protections are firmly rooted in the 14th Amendment guarantee of equal protection under the law. For nearly a century, courts have recognized parents' fundamental right to direct the upbringing and education of their children. In Mayer, Nebraska, 1923, the Supreme Court ruled that a law banning the teaching of foreign languages to young children violated the 14th Amendment Due Process Clause because it infringed on parents' right to direct their children's education and teachers' right to teach subject of their choice. In Pierce v. Society of Sisters, in 1925, the Supreme Court unanimously struck down an Oregon law requiring all the children between the ages of 6 and 8 to attend public schools, ruling that it violated the 14th Amendment Due Process Clause because it infringed on parents' liberty to choose private or religious education for their children. Your Honor, the petitioner do not ask this court to micromanage school curricula, but to reaffirm that the Constitution protects both parents' role in the children's upbringing and students' right to receive information without political censorship. Parents must be informed and allowed to choose when schools introduce sensitive or ideological topics to young children, and other students must be free to access diverse ideas without state-imposed orthodoxy. Therefore, the petitioner respectfully asks this court to reverse the 14th Circuit's decision and uphold both parental and students' rights within the classroom. Thank you.